Welcome to the RBFCU Trust Services webinar, Leave a Legacy, the Power of Estate Planning. We're here to learn more about trust accounts and discuss how comprehensive estate planning can provide security and preserve your legacy for generations. Today's presenter will provide some compelling reasons to consider a trust. My name is Amanda Ramos, and on behalf of RBFCU Trust Services, I welcome you to today's webinar. We have over 190 people from around the region registered, and I thank you all for joining us. Our goal is to provide you education and resources to better understand the role of a trust. We'll use an online poll to gain a better understanding of your level of knowledge when it comes to the different aspects of estate planning. And if after today's webinar you still have questions related to estate planning or trustee services, along with general questions about your financial goals and investment strategies, you may contact RBFCU Trust Services and speak with one of our trust program professionals at no cost and no obligation. It's just one of the benefits of your credit union membership. Also, throughout today's presentation, you can reference our contact details and other information in the chat feature found on your dashboard. I'm pleased to introduce today's moderator, John Rodriguez. In his role in the Trust Services Program, John is responsible for specialized trust services that meet the complex and multifaceted needs of individuals and families. He helps clients to define and implement estate planning and estate settlement strategies. John has served in the financial services industry for over 22 years. He holds a Series 7, 63, 65, 9, and 10 registration, along with a Texas Life, Accident, and Health Insurance license. John also holds a Chartered Retirement Planning Counselor designation, as well as a Certified Trust and Financial Advisor designation. John, welcome to today's webinar.
Thank you, Amanda. I'm honored to be here today, and along with our expert, we hope to provide you with some basics of estate planning. In my work with our Trust Services Program, we've met with many members who've had questions about trust, the steps to proper estate planning, and the facilitation of estate settlement. Given the long history of trust and the numerous varieties, it's not surprising at all that most people don't understand. Yet, when it comes to protecting your legacy, the right planning can help preserve your assets, avoid probate, and even support a loved one in need of special care. So I want to thank each one of you for being here today and for your interest in learning more. Before I introduce our presenter, we have an online poll question for you. We're interested in better understanding your level of knowledge when it comes to estate planning. So our poll question asks, how knowledgeable are you about the different aspects of estate planning? Are you very knowledgeable, somewhat knowledgeable, not too knowledgeable, or not at all knowledgeable? Take a moment to select your answer, and we'll monitor the voting and show you the results in the next minute or so. While we await everybody's response, I just wanted to mention that an estate plan is only as sound as the person or entity charged with its execution. So in other words, a well-drafted estate plan may fall short without a detail-oriented and fair trustee. Serving as trustee involves a significant amount of work that can be overwhelming when stacked on top of existing work, family, and your community responsibilities. So fortunately, as a member, you do have access to product and service options, including trust services. RBFCU Trust Services can serve as your corporate trustee and help in the facilitation of estate settlement. Okay, I believe that everyone has had some time to respond, so with the help of our webinar team, please show us the results. And we're looking at the top answer of 44% is not too knowledgeable. So that's why we're here today. It's a good reason. So let's quickly review today's agenda. You'll learn about the basics of estate planning, including the goals of estate planning, exactly what you're trying to accomplish, the method of estate planning, which includes the tools used or not used to achieve those goals, and the fiduciary selection, a main component to making sure your plan is successful. Also, don't forget to download the handout available in your webinar dashboard. And following the webinar, we ask that you please complete our survey We always like to know what it is that we're doing right and could improve on. And that survey will appear automatically in your browser when the webinar ends. I'm pleased to introduce today's presenter, Beverly Davidek. Beverly has been a practicing attorney for more than 25 years, and most of those years have focused on areas that directly affect families, especially families with children: wills, trusts, guardianships, school law, and general counsel for family-owned businesses. Beverly understands firsthand the importance of having all your ducks in a row so you can sleep at night, knowing that you've done all that you can do to take care of your family from a legal and financial standpoint, as well as from a spiritual and family legacy standpoint. Beverly, welcome to today's seminar.
Thank you so much, John. I'm delighted to be here, and I have a feeling this is going to be a very informative presentation for our audience. And I just want to say hi to everyone and thank you for being here. As John mentioned, my name is Beverly Davidek, and I'm the owner of Davidek Law Firm in New Braunfels. My presentation will be addressing two key concepts in estate planning. Number one, what goals are we trying to accomplish when we do estate planning? In other words, why did you take the time to attend this webinar today? And to be fair, there are really no wrong answers to that question. As John mentioned, I've been an attorney for a long time, and it really does appear that there is an endless number of right answers to that first question. And then the second concept I will touch on today is, what are the different methods that we can utilize to accomplish these goals? And then finally, towards the end of this presentation, I'm going to turn it back over to John, and he will discuss fiduciary selection. This means that once you put a plan in place, then who's going to ensure that the implementation of that plan is done correctly, as he mentioned? Who's going to be able to step in and manage your affairs for you when you can't do it anymore? And so we'll talk a little bit about how to make sure the people that you choose are the right people or the right entity for that. So what are some of the goals that people want to accomplish when they are estate planning? Obviously, a big one is number 3 there on your screen, which is leaving a protected legacy. Of course, we all want our assets to pass efficiently and easily to our loved ones when we pass away, and that is what leaving a protected legacy is all about. But we also want to make sure that in doing so, we don't lose control of our assets while we're still alive. Things change in everyone's lives from year to year. New people come into our lives, others pass on, and while the law has also been known to change from time to time, you may have heard something about that as well. And so we want to make sure that your estate plan has the flexibility to adapt to all of these changes when it's necessary to do so. We certainly don't want to have to recreate your entire estate plan every time something changes in your life, so we need that flexibility. And then finally, everyone, and I do mean everyone, young or old, should have a backup plan in the event of their incapacity. This is one of the most overlooked concepts in estate planning, but one that can save your life and your bank account truly if done properly and if done by an experienced professional. So let's talk about some key concepts that you will need to understand as we progress through this presentation. How we define incapacity and the concept of probate are absolutely essential ideas to understanding how to properly estate plan in order to meet your goals. Incapacity means, and you are familiar with this, I'm sure, it means that you're unable to provide for yourself. The most common form of incapacity occurs when you can't provide your own food, your own clothing, or your own shelter. You're physically unable to care for your own needs. But an often overlooked and yet equally important part of incapacitation is that you'll often be unable to manage your own financial affairs as well if you're incapacitated. And unfortunately, life being what it is, many or most of us end up going through some degree of incapacity at some point during our lives. And so our goal in proper estate planning is to make sure that we're prepared for incapacity when the time comes, if that time ever comes, and to ensure that whether we regain capacity at some point later in our lives, or we remain incapacitated indefinitely. Either way, our physical health and our financial affairs are in the hands of the people in our lives that are most qualified to make those decisions for us. Now, probate is another concept that is absolutely essential to our understanding of proper estate planning. Probate is the court-supervised process of transferring legal title to your assets after you pass away. Over many years as a practicing attorney, I have found that there's a lot of misunderstanding surrounding the probate process. For example, many people think, well, if I have a will, then I don't need to worry about probate, right? This is absolutely not the case. All last wills and testaments must be probated in order for the will to be an effective method of passing your assets to your loved ones. And the irony of the probate process is that it is actually the opposite of what a lot of people think that it is. Probate is actually a lawsuit that you pay for with your own money in order to protect the interests of disgruntled heirs and your creditors. A lot of people don't think about it that way. So let me give you an example of why this can be particularly troublesome for your estate. Let me illustrate this. Picture a scenario where you have 3 beneficiaries, but you leave your assets to them in uneven amounts. Maybe one of the beneficiaries becomes frustrated because in their mind, you didn't include them enough in your distribution plan. This happens more often than you might imagine, and we see this in our office quite frequently. And if your estate plan does not need to go through the probate process in order to get ratified, so to speak, the only possible avenue for there to be a challenge, for somebody to challenge your estate plan, is to hire an attorney, pay that attorney thousands of dollars, and then file the challenge to your will on their own. But when you create a will, or even if you have no estate plan in place at all, your estate has to go through the probate process after you die. And all that disgruntled beneficiary then has to do when they're challenging the estate is to hire an attorney to take the case on a contingency fee and try to disrupt your plan. In other words, there's already a lawsuit in place for them to jump right into when there's a probate involved. So this means their filing fee is going to be very low, and the simple probate process that should have been now becomes extremely complex and expensive for your estate. Now in probate, the court will eventually appoint an executor who is a fiduciary, meaning that they have a duty of loyalty to carry out the terms of your will. The reason why we have a probate system is because when you create a will, you're basically telling the court, here's who I want to get my stuff. The problem, of course, is that you're not there at that time to make sure it happens. And so the government has decided that it must supervise the transfer of your assets. And it does this by naming an executor to step into your shoes and then distribute your assets according to your wishes that you have laid out in your will. So the number one lesson to take away from this slide is the fact that a last will and testament does not avoid probate. Instead, your will is a non-refundable admission ticket to the probate process, if you think about it. And in order for your will to be effective, your will must go through the court process. Now, probate can also take anywhere from a few months to a couple of years to complete, depending upon the complexity of the case, the size of the estate, the court's docket, including which county you're in, and the areas of law involved. The problem with this is that financial institutions will often lock your bank accounts, investment accounts, retirement accounts, and other assets while your estate is going through the probate process, forcing your beneficiaries to pay for burial expenses, memorial services, mortgages, car payments, bills, and any other debts owed by the estate out of their own money until they can successfully navigate the probate process. So someone has to pay the bills, or perhaps risk foreclosure, repossession, or other legal repercussions. And in fact, I've seen several estates fall into the hands of creditors because the beneficiaries couldn't afford to pay mom and dad's bills. The costs of probate were prohibitive, and also they had a hard time keeping up with their own finances. So forcing your loved ones to go through the probate process can unwittingly put your beneficiaries through financial hardships of their own which isn't something that I believe any of us would want to thrust upon our loved ones' laps. One downside to probate is obviously the delay that it can cause, which I was just talking about, and the hardships that this can put on your loved ones through once there is a lockdown of the assets, involving all of your accounts and assets. And in my office, we recently had a case who involved a client whose mother passed away and left her a house, left our client a house with a mortgage attached to it. And due to a lot of delays in the probate process, that were no fault of ours, no fault of our clients, that probate ended up taking over a year to complete. By the time we were able to complete it, the mortgage lender had foreclosed on the property. And there are a lot of lenders out there who unfortunately are not going to be sympathetic to the death of the borrower. It can really be kind of a cutthroat process sometimes. And so if we can afford to remove the probate process from the equation, that's typically, or in my experience, really always going to be the best option. There's also the cost of probate to worry about. The average cost to probate an estate in Texas can range anywhere from $3,000 up to $20,000 or even more, depending upon so many different factors. There will be attorney's fees, of course, but there are also appraisers' fees, required bonds sometimes, ad litem fees, creditor fees, and of course, there will always be court costs, and all of these costs really add up. So a golden rule that I often tell my clients when I meet with them is that you never want to leave decisions regarding your estate and your assets up to a court of law to decide, because the court's ideas of what is fair and just may be very counterintuitive to what you believe to be fair and just. Now, probate records and often the court hearing itself are available for anyone who wants to access them. So here's another downside to probate. These processes are a matter of public record. And so anyone can find out what the assets of your estate are, as well as many other personal details, not only about your lives, but your beneficiaries' lives as well. And I don't think any of us would voluntarily throw our personal information out into the public sphere at any point during our lives, but that's exactly what you're doing when you enter the probate process. And then, of course, we've already talked about the fact that you're creating a forum for any disgruntled heirs to just appear and challenge your estate plan. So all of the things that I just described about the probate process can be completely avoided through intentional planning, and that's really what I'm here to talk about. When I talk to my clients about the goals and methods of estate planning, what I'm really telling them is that I want them to have as much control as possible of the disposition of their estate without the burdens of probate on their loved ones. So now that I have touched upon some of the goals of proper estate planning, let's now discuss some of our methods of estate planning, some of which are wonderful tools and some of which are, well, maybe not so much. For simplicity's sake, we're going to narrow down estate planning to the 4 most common methods. Now, pretty much all of us have mastered number 1, which is to just do nothing. That's what we're born with, and that's the easiest for you to do. It's actually the most common, but it is definitely not the best option for your family. Doing nothing means that you're just hoping that it all works out in the end, but by doing nothing, you're putting your spouse or other beneficiaries at serious risk of incurring all of the probate expenses and heartaches at a time when they are most vulnerable. Unfortunately, as I mentioned, that's what most folks do, and I'm hopeful that you'll choose a different option. So let's move on to the second method of estate planning, and that is planning with beneficiary designations. This means having specific types of bank and retirement accounts, such as a pay-on-death account, a JTWROS or joint tenants with right of survivorship, or designating beneficiaries on your retirement accounts. These all can be useful tools in a comprehensive estate plan. It can be useful, but no combination of these tools, just these tools, will ever substitute for a well thought out estate plan. So they have their place, but they are not a complete plan on their own. The third and obviously most well-known method of accomplishing estate planning is by using a last will and testament, which I'll talk about in greater detail later on. And then finally, I'm going to talk about my preferred method and what most estate planning attorneys would agree is the gold standard of estate planning, and that is to have a revocable living trust as an estate planning device. All right, so first let's address doing nothing. The first thing you need to understand is that if you've done nothing and you become incapacitated later on in your life, there's likely going to be a guardianship proceeding happening at the same time that your family is the most stressed out because of your condition. Your family members are going to be trying to manage finances, get the best care for you, and make all of the arrangements needed to ensure your well-being. They probably won't be able to do that without guardianship if you've done nothing, meaning that they'll have to go to court, pay the filing fee, do an accounting, post bond, hire attorneys, and spend a lot of money. But the fun doesn't stop there. Once you pass away, if you've done nothing, that means that you've died without a will or other estate planning device, and that means that you've died intestate. Intestate is the estate plan that the court will put in place for you when you pass away if you have not created a plan for yourself. And like I said earlier, this plan is often very counterintuitive. It's the opposite of what you would sometimes think it would do. The important thing to remember here is that the court's estate plan, it's not what you've probably envisioned for your estate if you had taken the time to plan properly. First of all, the court's going to force your estate to hire an independent investigator. That's called an attorney ad litem. And what they're going to do is come out and investigate who the rightful heirs of the estate are. This means that there has to be what's called an heirship proceeding. So let's say that you pass away and you didn't have a will and your spouse wants to sell the house, but your share of that house is in your estate. Your spouse is not going to be able to sell the house without this heirship process taking place. The attorney ad litem will contact multiple people knowledgeable about your estate. They'll ask how many kids you have, how many other family members might be interested in the estate, et cetera, et cetera. And we have to remember that these ad litems, well, they're getting paid hourly, often $200 or $300 an hour. And so unfortunately, it's not unheard of that some of them tend to abuse the system. And they may create problems where those problems would not really exist, just to extend the process and get paid more money. So I hate to say it, but ultimately the ad litem, after possibly spending more money, more of the estate than is necessary, finally they will file a report with the court, and the judge will make a determination about who the heirs are. But the process is still not done at that point. There will be a second court process after the heirship proceeding, where we request that the court name someone to become the administrator of the estate. This is who would have carried out the terms of your will if you had had one, except that you don't actually have a will in this scenario, and so the state drafts one for you. So Texas will write a will for you, and it's usually, as I mentioned earlier, not the one you would want. And then, of course, there's the blended family surprise, where if you had a child from a previous marriage or a previous relationship and you die without a will, your children will get the assets, not your spouse, which can really put the two sets of beneficiaries at odds with one another. Now, another method that people sometimes try when they're estate planning, what they'll try to do is to just use beneficiary designations. Oftentimes people will think, I don't think I need a will. I'll avoid probate because I've got beneficiary designations. So let's look at an example of that. Let's say that someone is a single person and maybe even a widower, and they have 3 grown children. And in this example, maybe they leave a $200,000 life insurance policy to the oldest child through a beneficiary designation of that policy. They might leave a house that's worth $200,000 to the middle child through a transfer on death deed or a ladybird deed, some folks have heard of in Texas. And they might put the youngest child on a bank account that's also worth $200,000. Well, if the kids need to sell the house during the parent's lifetime, where are they going to put the proceeds? They're going to put the proceeds in that bank account. Now, when the parent dies, one of the kids will end up with nothing because there's no longer a house in the estate, and another kid will end up with double the inheritance that they were supposed to get because the amount of assets in that bank account doubled when the house was sold. So you might think, well, then the one child can just gift the value of the house back to the other child who got nothing. And while that may be true, if that child is good-hearted enough to do that, but even then, that's a taxable gift that has to be reported to the IRS. So it's going to have tax consequences that could have been avoided through proper planning. And this is only one example of a lot of problems that can come up with this type of planning when it's used in isolation. So as I mentioned earlier, using these designations can be a nice idea, but it often doesn't work. For example, let's say that you have a child that you've named as a joint account holder on your bank account, and all of a sudden the child gets sued or gets divorced or has creditor issues, maybe even a bankruptcy, whatever it is that's just happened to them. Well, you guessed it, your bank account could very well be locked out and taken from you. So this is another kind of thing that we see in my office all too often. And so please always remember that the simplest way to estate plan isn't always the most secure and efficient way. Now, I'm sure that most of you out there, probably everyone, has heard of a last will and testament. And while I would never want to disparage a will as an estate planning tool, it is certainly better than nothing at all, but it's just not the most effective tool that we can use. First of all, you need to 100% understand that a last will and testament does not avoid probate. As I mentioned earlier, it does not avoid probate, and it's a very common misconception in our society today that it will accomplish avoiding probate, but it does not. And as I've already mentioned, if you use a will, it is only effective upon your death. So it won't help you if you become incapacitated. If you only have a will, you'll be relying on a power of attorney to help facilitate your wishes during the time of incapacity. And here's what happens all too often. People will sign a will and they'll sign a power of attorney, and then they'll put those documents in a drawer, put it away somewhere, put it on a shelf, and they have a sense that there's some peace of mind there, but it's a false sense of security, because then perhaps some sort of incapacity happens 10 years later, however long it might be. Your loved ones are going to open up that drawer or go to that shelf, pull that binder or that envelope down, and then they say to themselves, wait a minute, this power of attorney isn't going to work. I'm not going to be able to manage mom or dad's assets. And this is because financial and medical institutions don't have to accept your power of attorney, either due to the power of attorney being outdated or the law having changed, or maybe it's just from a different jurisdiction. And we see this a lot in my office as well, with so many folks moving to our wonderful state here. But whatever the reason is, sometimes people don't find out until their family's power of attorney, mom or dad's power of attorney, won't work. They don't find out until it's too late, unfortunately. And once it's too late, there's really nothing that we can do for you at that point, other than some of these unfortunate circumstances I've already talked about, like guardianship. So let's talk about higher costs. Most people are misinformed on this as well, but it's not their fault. They just don't realize that the law firm that just prepared your will for you, in all likelihood, they're going to make more money when you pass away. And that's because they're probably going to get the probate work as well. So if you're married, that means that there'll be 2 probates that they profit off of, and potentially a guardianship as well. So lawyers will actually typically get paid more over the long term of people who use a will-based plan, because that will-based plan did not avoid future costs, like the cost of probate. And as I mentioned before, there's a delay to our loved ones receiving our assets, because probate is all about putting the estate's creditors first and foremost ahead of our loved ones. And as we talked about, a will is easily contestable because there's already a lawsuit that's filed for that disgruntled heir to enter into. And then finally, this method breaks several of the commandments of estate planning, most notably that the probate process is a public process, so things are not kept private. Most folks that I work with on a daily basis really highly value their privacy. And also, with regard to that, an inventory must be filed in a probate, so people will know what your assets are worth, and all kinds of other private information, not just about you, but also about your loved ones as well, because they'll know who those beneficiaries are. So what's the answer to avoid all of these costs and headaches? The answer is going to be using a revocable living trust. The revocable living trust is actually my preferred method for most of the basic estate planning that we do in my office. Using a trust means that not only do you control your property while you're alive, but it will also allow you to leave a protected legacy to your loved ones when you pass away. It means that you have a backup plan in place in case you become incapacitated. It also provides for a plan in case you have minor beneficiaries or perhaps beneficiaries with special needs. These are two situations where you never want to use an outright distribution plan that a simple last will and testament would provide for. Leaving assets to minors outright will cost your estate thousands of dollars, as judges are very protective of minor beneficiaries, as they should be, and will in most cases force your executor to create management trusts that end up costing the estate avoidable expenses. And you also never want to leave your estate to special needs beneficiaries outright, as this can severely affect the beneficiary's ability to receive disability benefits or other special needs benefits. And in fact, the government has been known to actually stop benefits for the disabled beneficiary to reach in and, to use the term that's kind of a strong term, but I consider it confiscating that inheritance that they just received as payback for the benefits that that beneficiary had received in the past. And so you would actually just be handing your estate to the government in that situation, while also disrupting that beneficiary's disability benefits. Quite the disaster. Well, a properly structured trust would provide second spouse protection with regard to things like avoiding estate taxes, Medicaid qualification, and of course, avoiding the probate process, and can even provide asset protection for your heirs, which is a huge benefit to them. Imagine a scenario where you have passed away and you leave your assets to a beneficiary who's going through a divorce, or who has a creditor issue, or bankruptcy, or the court just issued a judgment against them, or any other financial pitfall that we can all fall into from time to time. In any of those cases, if you distribute your assets outright to your beneficiaries, those assets are in jeopardy of being taken away from them by another person or entity. But if you leave the assets to them in trust, then the assets will be protected for them for life, which would provide them potentially a lifetime of security and comfort. It's the goal, right? And then of course, as we discussed earlier, a trust helps to keep the assets in the family by avoiding creditors, avoiding probate costs, and avoiding any type of unwanted challenges to the will. And so it really is the gold standard of estate planning. Now, if we take a look at this slide, we can see that only a trust will allow you to 100% efficiently control the property while you're alive, so there's no loss of control, while also providing you with an effective backup plan in case of incapacity, and then of course allowing you to leave a protected legacy for your beneficiaries. None of the other options even comes close to providing the security that a living trust can provide. So again, a trust is really the gold standard of efficient estate planning. So what exactly is a trust? I always like the graphics on this slide. Think of a trust as a bucket. It's the bucket on the left side of your screen. So think about that as a bucket. That's your trust. It holds all of your assets. So if you create a trust, your hand is always on the bucket. Now, there are actually three positions in a trust. There are the grantors of the trust, or the people who are granting their assets into the trust, which is of course you as the creators of the trust. So you're the ones deciding what goes into the bucket or into the trust. And then there are also the trustees of the trust. While you are alive, you are the trustees of the trust. What this means is that you are the controllers of what happens to the assets inside of that bucket. If you need to sell property, buy new property, gift away property, whatever you want to do with your property while you're still able to do so, that's what you would handle as the trustee. So nothing changes whether you have your assets titled into your own name individually, or if you have assets titled into a trust name. Nothing changes from that perspective. And then finally, there are the beneficiaries of the trust. Who benefits from the trust? So while you're alive, you're always the sole beneficiaries of the trust. You play all three roles inside of this trust: grantor, trustee, and beneficiary. And one of the most common things that potential clients, when they come into my office, will say, and when they first hear about a trust, is they'll say, well, I'm not sure I want a trust because I don't want to lose control of my assets. But as I mentioned, you still retain control of your assets. So in fact, their concern is really far from the truth of what actually happens. The trust would actually provide you more protection than if the assets were in your own name. And that's because if you were to become incapacitated, you're going to decide who holds the bucket for you while you recover. So this eliminates the need to appoint a guardian of the estate. The person who's called the successor trustee, or could be an entity as the successor trustee, they're going to be named, and that essentially works like a guardianship of the estate if you were to become incapacitated, potentially saving the estate tens of thousands of dollars. The trust document, to paraphrase it, basically says that while you're alive and well, you're going to be the trustee along with your spouse if you're married. And if you're both not able to act on behalf of yourselves, then the trust says, okay, here are the adult children or someone else who is now going to serve as trustee of the trust. And that way we don't have to go to court to have someone manage the assets. And then when you do pass away, the trust works to avoid probate, because ultimately, when we finally get through the probate process, you're asking the judge for permission to transfer assets out of the deceased person's name and into the hands of your beneficiaries. But with a trust, you don't need to remove the assets from the deceased person's name because the assets are already in the trust name, not the deceased person's name. So in other words, this is an immediate transfer. Immediate. The day you take your last breath is the day that your beneficiaries will have access to these assets. And that's because you will name a successor trustee to move up and control the assets in the bucket, and then they will distribute the assets according to your wishes. So this is an instantaneous transfer, unlike the perils and pitfalls of the probate process that I talked about earlier. And so now I'll give you an example of how a trust can be an effective tool. In a married situation, if one spouse becomes incapacitated and the other one wants to sell the house, the title company would look at the deed, and if the deed says that the trust owns the property, the title company would look at the trust, and the trust will say that either one of them can do anything on behalf of the trust. So the spouse with capacity would have no problems doing what they need to do. The whole process is so much easier. So if you think about it, you have more control than you would without a trust. You're able to manage your assets while you're capable of doing so. And so you're basically saying, we don't need the government to help us manage our assets. We can handle our own assets unless we become incapacitated, and then we have a successor trustee. No need for the government to step in, no need for a guardianship. And then the last picture there says, when you kick the bucket, when you pass away, the trust says, okay, here's who gets the assets, and it does, again, not have to go through probate, and your family can handle the affairs. It's so easy, so why would you want to put your loved ones through a court process upon your incapacity or your death? Probate is voluntary, it's not necessary, and not going through it can save your family thousands of dollars and a lot of heartache, a lot of time. So you can see how effective a trust is at allowing you to control your assets while you're alive, but another advantage to the trust is that you can customize it to support your loved ones and or charitable organizations after you die. A trust is an extremely flexible document, and I'll give you a couple of examples of how you can organize it to achieve these goals. Imagine that you have a son or daughter-in-law, doesn't really like a traditional job because, well, that traditional job doesn't really fit in with their idea of the perfect plan for their life. Maybe they even have a drug or alcohol problem, or a gambling problem, or just a greed problem. Maybe they're just greedy. And maybe they also think that it's great that they have what they consider to be rich in-laws. Maybe that's you. And they think that when you pass away, your assets are going to your kids and they're going to reap all the benefits. So if this scenario is one that hits close to home for you, well, you're probably going to want to avoid that. So what we could do, for example, in a situation like that is to create a trust that says, when my spouse and I pass away, our assets shall be split into separate shares for our children. Those separate shares are each going to be irrevocable trusts, meaning they cannot be changed. My sons are going to be able to be the trustee of their own separate trust and they can manage it, but that truly will never become a part of any lawsuit. That trust is their trust and it cannot be a part of any lawsuit, including a divorce. And so it really does protect them and give them full control when we have that type of planning. And we set those up in our office all the time. And this is a good thing for families for whom that's an issue, because what happens is typically people leave assets to their children, and those assets are in the name of the child, not in a trust. And because Texas is a community property state, most assets in a marriage relationship end up being owned 50-50. And so if your child's spouse divorces your child, they might have a nasty divorce lawyer making a claim for a share of the trust assets. Even if you're familiar with the term separate property, which removes it from being community property, but that's what the divorce lawyers make a lot of money arguing about. And so, typically your child will not have separated out that property from the community estate. Most couples don't do that. And so this could result in the unintended loss of their inheritance in the divorce. But as I mentioned, if you leave assets in trust for your son or daughter, they can control what happens to their assets if you want them to, but they just cannot lose them in a divorce or to creditors. So this is another wonderful asset protection example. Here's another one that I can give you, and it says that when you pass away and then your spouse passes away later, your assets go to your son or daughter, and then the next year your son or daughter gets into a car accident. Okay, what a horrible example, but again, it's all too common, and so I want to illustrate this for you. They get into a horrible car accident and unfortunately they pass away. If they're like most people, they probably have a simple will at best, and they give everything to their spouse. Well, there goes the inheritance to your son or daughter-in-law. That's where your inheritance is going. And so in that scenario, your grandchildren might never see those assets, okay? Because if the son or daughter-in-law ends up inheriting those assets, which is not what you probably intended, well, what if they get remarried? And so they might actually end up passing on those assets to somebody that you've never met, and maybe your grandchildren wouldn't get anything, or perhaps very little. So again, these are unfortunately all too common scenarios. And they might seem far-fetched, but we see them a lot more often than we want to in my office in similar examples. But instead, if you leave assets in trust for your son or daughter, that trust is going to say that if your son, in my example, predeceases you or passes away with assets that are still in his separate trust, then those assets go to the grandkids and not to the spouse. And so that's the kind of planning that we want to be able to do for you. And we can ensure that your legacy is protected in whatever way you want it to be, which for most folks means that they want it to stay in their family or go to a charity of their choice. And then finally, a trust can preserve family harmony. Wills, beneficiary designations, and other lesser effective estate planning techniques just do not provide the almost foolproof protections that a trust can offer. The amount of sibling relationships that I've seen decimated in the probate process is staggering. And so to me, it's just a no-brainer to ensure that our estate plans have no room for ambiguity. We need to ensure that, and that means it needs to be rock solid in order to eliminate any room for bickering amongst our loved ones. Now, a revocable living trust is by far the most common type of estate planning trust in the United States. There are other types of trusts, but if you have a specific concern within your family, there are other specific types of trusts that might suit your needs a little better. If you're concerned about asset protection, about Medicaid qualification, you might consider an irrevocable trust during your lifetime. If you've been diagnosed with a condition and you want to ensure that when the time comes that you need additional care, that your estate isn't drained in order to pay for your care. Maybe a special needs trust might be what you need. And testamentary trusts are also another type of trust that can help to accomplish some of these goals. And then, of course, if you have a specific charitable donation in mind that you would like to leave as your legacy, a charitable trust can help to facilitate those needs while also helping to eliminate estate tax consequences. So you really do have a lot of options when it comes to the type of trust that you want to create, depending upon your current situation, your current condition, and your future prospects. But again, most of us will really only need a revocable living trust to accomplish most of our estate planning needs, and that's because it will accomplish most estate planning needs in an efficient, effective manner while allowing you to remain in control of your estate while you're still alive and have capacity. Revocable living trusts are flexible, they're easily modified or revoked if need be, and they provide an amazing backup plan for you if ever you were to become incapacitated. Revocable living trusts are really the gold standard of efficient estate planning, as you've heard me say a few times. And then one final note before I hand the controls back over to John: special needs trusts are an extremely important tool to allow us not only to provide for ourselves and our families in case of our own incapacity, but they're also absolutely imperative for any beneficiary who's receiving any type of needs-based benefits due to a disability or incapacity. Of course, the special needs trust will allow for financial assistance for someone with special needs, but it also allows that beneficiary to remain eligible for government programs. And it really is the difference between the beneficiary receiving both the benefits of the inheritance you leave them while not interfering with their currently structured benefits programs. Always keep in mind that long-term medical care is extremely expensive, and oftentimes the benefits your beneficiary may be receiving only cover the most basic of services. So creating a special needs trust can allow those beneficiaries to receive these minimum government benefits while also giving them a nest egg to supplement any additional medical or living expenses that those benefits do not cover. So it's absolutely essential that if you have a diagnosis or a disability, that you consider creating a first-party special needs trust for yourself. And if you have a beneficiary with special needs, that you consider leaving your assets to that beneficiary in a third-party special needs trust. All right, well, that was a lot to cover, and that does conclude my portion of this presentation. And so I'm going to go ahead and turn the controls back over to our moderator, John Rodriguez. I want y'all to know I've really enjoyed this time together today, and I thank you for attending. I sincerely hope that we see some of you at the Davideck Law offices at some point in the near future so that we can help you to develop an estate plan that's right for you. So thank you all again, and John, you can go ahead and take it away.
Thank you very much, Beverly. We really appreciate that. So I wanted to spend a few minutes and go over what is important for the trust department here at the credit union, and I wanted to focus on the successor trustee, or the person or entity that settles the estate. That is something that we can do. If we look at the trustee duties, those duties of the trustee are quite a long list, as you can see, and hopefully the layman is not going to make a mistake in performing all of those duties. I've had the pleasure of helping our members for over 20 years as an investment advisor and now a trust officer. And I wanted to give you a few examples why more and more of my clients and credit union members are choosing the credit union as their successor trustee to settle their estates. We will have expert handling of the settlement. Unlike laymen, that is very probable that they might make mistakes in settling the estate. We have the obligation to be thorough. We avoid setting up your loved ones for conflict if they don't all agree, and of course they rarely do. We're there to do the job seamlessly. Continuity. We're always available when your loved ones might not be available, capable, or inclined to do the job. We can remove that stress. We can reduce strain in blended families so you don't have to choose one child to do the settlement, you can have us do that job. Many times grief and money don't mix very well. We can also expertly handle special needs accounts to manage assets and distributions for your minor or adult special needs loved one, especially for those that are getting Social Security benefits, that they have to be handled in a very particular way as not to interfere with those benefits. So what I hear the most from our members is that they don't want to burden their beneficiaries and would love the credit union to do the job completely. Randolph Brooks is partners with Members Trust Company to settle your estate. We have a network of attorneys like Beverly and the Davideck Law Firm that we can refer you to. We love to give you personalized service, and we always like to meet with our members prior to meeting with the attorneys, just to prep them and inform them of expectations before visiting the attorney. We've reached the end of our time today, and I'd like to thank our expert, Beverly Davideck. We hope you've learned some valuable information about estate planning. I'd also like to thank all the participants. Following the webinar, we ask that you please complete our survey. The survey will appear automatically in your browser when the webinar ends. We value your feedback so that we can continue to improve upon our educational resources. Also, please remember, if you still have questions related to estate planning or trustee services, along with questions about financial goals and investment strategies, please contact us at RBFCU Trust Services, and you can speak to one of our trusted program professionals at no cost, no obligation. You can call us at 210-637-4117, or you can email us at trustservices@rbfcu.org. Thank you for your participation, and enjoy the rest of your night. Goodbye.